Yes, people. So in this video, what let us try to do is, let us try to focus on your RTP applicable for September 2026 and onwards. So in this, let us try to see the last questions. Let us try how to answer. And I'll try to also tell you how to even read the question. As I always tell, right, there will be hints in the question. We can pick up that and we'll be able to write the answer. So I'll also tell you the art of reading the question also, one of the most essential thing, so that you will not get confused, sir, which provision to apply, this or that. That only is a confusion. Let us try to see that also. And also let us try to sum up what are the some common mistakes that the students do. Let us try to avoid doing that. Clear? Yes, all of you? Okay, chalo. So first thing, yes, an amendment is there applicable for your attempt. Small company is not 4 crore and 40 crore. For your attempt, it is paid up capital not exceeding 10 crore, turnover not exceeding 100 crore. And rest of the conditions is as it is. That is other than public company, that is as it is. Clear? Okay. Yes, sir. Let us start with questions. What is that? What do you understand by law? Also elaborate the procedure of making law. What is law, people? Law is something like set of rules and obligations which govern the country. It can be different types of law, social, economic, as the case may be. How is the procedure to make law? Now, what is the tip here, people? Again, if I have to tell everything in one place, okay, tip number 1, always remember, common mistake students do, you should not do. The first question should be your most confident question. Remember, reach early, read the question paper carefully. Not only first, if you ask me, people, please try to maintain at least up to 1 to 3 or 1 to 4 questions. Please try to maintain utmost clarity. Don't write these questions in your own words. Pick up such questions only. And generally, what will students do? Sir, writing a direct question is easy. No. Trust me, you know, I know that we don't know a direct question. If you ask me, for us, direct question is the most difficult one compared to an indirect question. Because direct question is, you know the concept, but you know nothing directly given in the book. 1 or 2 points you will know. It will be for 5 marks. So you know, I know that it is our biodata. You have written something. Or people, you would have done the jalebi of the same one sentence. Yes, I would always suggest, let the first question be a indirect question. Yes, always. Clear? And point number 2, just now I told you, there will always be, people, 3 things in your answer. Provision. So go with the format. We have already discussed what is a format. The format, people, try to stick to. The first paragraph will be your provision. This should be the maximum part. Let us imagine if it is a 5 marks question, your provision carries 3 marks, your facts carries 0 marks, your conclusion carries 2 marks. So facts is nothing but, people, it is the artistic way of presentation. For the answer to look right, you're writing facts. Keep it as less as possible. 2 lines, 3 lines, more than sufficient. Now, when I'm writing the format, I told you this is a format, remember. Now, how to get that 3 on 3, sir? This is very, very important. Just now, whatever we saw, people, is our answer will always have 3 main things in it. If you just want 1 mark, just write the heading. Yes. Now, for example, people, there is a transfer of property from a father to a daughter. The father met with an accident. The daughter wants to claim the property. They're asking you, is this a valid contract or not? What will you write? So the father has written everything on a piece of paper. Yeah. So is it a valid contract or not? There will be a question. Now what will I write? For me to get this entire 5 marks, this is how the answer will go. First heading, people, I will write exceptions to quid pro quo. That is my heading. Exceptions to quid pro quo. That is my heading. Now there is a subheading also. What is that? For a contract between father and a daughter to be valid, it has to be, subheading is now important. It should be out of natural love and affection. Now comes, people, keywords. Now I have just written, it is quid pro quo, natural love and affection. Now under natural love and affection, people, there are keywords. What is that? The document should be mandatorily in writing. They should be in near relationship, and people, it should be mandatorily registered. How long did it take us to write this? Now remember, if this is there, you will get 3. Now any sentences connecting these 3 things, you write in your own language, it's absolutely fine. It will make 0 difference. But please don't change anything in these 3. This is the art. Now from today, when you guys are writing question paper, remember this. Your mind has to first tell you, heading, have you written? Subheading, have you written? Now check for, are there any keywords? If you write only heading, you will get 1 mark. If you write heading, subheading, you will get 2 marks. You write heading, subheading, keywords, you will get all 3 marks. Hello? Is this clear, all of you? Now, point number 4, you figured out what to write. Please don't write everything in a paragraph. Please try to put it into points. And point number 5, I know what to now underline. Please underline them. Underlining is the key. Please don't give extra effort to the evaluator. Let us respect their job. Hello? Very, very important. All of you, I don't know if I have answered this question in the class or not. Now, most of you will have this doubt. Sir, should I remember the section? Is it important for your level? Forget. I'll be the only faculty telling in this country to tell, forget the section. And I mean it. Don't worry. It's okay. Remember, you are in the first stage of CA. They are not going to expect so much out of you. You are kids. If you are able to write it, it's good. And I'm telling you, and I mean it. People even writing final level, they will struggle to remember sections. Do you really think they will deduct 1 mark for you not writing the section? Answer is no. I am a living witness. I have seen papers who have got 80, 78, 76 without quoting even 1 section. So stop putting efforts here. If you can remember, of course, you can impress little. I'm not denying the fact. But if you do not know the sections, it's okay. Do not stress your mind. Our opening statement, as per the relevant section or as given under the Indian Contract Act, this topic comes under, write down like that. That will be your opening statement. Is this clear, all of you? Hello? Pakka? Remember that. 7th one, most important one. Remember, please maintain the time. Your first 1 hour, you should be done with at least 30 marks. Your second hour, you should be at least around 60 marks. God has given you an exceptional talent to cover people 100 marks. It is 40 marks in the last 1 hour. That means what? Constant check on time is very, very important. Do not realize it. Don't look at the time in the last hour. And that time, people, please don't draw bullet trains. We don't want snakes and bullet trains in the answer. You know, I know that we don't know anything that they have written there. And don't come and tell me that time, sir, I attended 80. You know, I know. The last 3 questions is bullet trains. Correct? So maintain decent pace from question 1. Very, very important. Do not overwrite. Do not overwrite. Especially don't waste time on facts. It's okay. And I'm telling you, in the last 1 hour, you'll be writing those questions. No, don't even write facts. It's okay. Leave facts. Because remember, writing one whole question is more important than you filling the facts, which will not even give you 1 mark. Are you getting the point? Yes, that is very, very important. Do not overwrite or underwrite. What do I mean by do not overwrite or underwrite? Remember, people, if at all, the best thing I can tell you is, if there is a difference between, you are expected to write all the points. You are expected to write all the points. You can't just pick up the, what do you say? Sir, 3 marks, no. 3 points I've written, more than sufficient. If 7 points are there, you're expected to write all the 7 points. Sir, next one, in difference between, we'll have one more question, sir. Should we write the basis of difference? If you can remember, very good. If you cannot remember, try to add the basis of difference in the difference only. Now, for example, definition, instead of writing, directly write what agreement defines as. So definition, define is there, underline that. Hello, I getting the point? And this is where I told you to remind me, you didn't tell me. Draw. Now what is draw? Illa, not right time. Now remember people, whenever they're asking you anything in Indian Contract Act or Sale of Goods Act, especially Negotiable Instruments Act, draw it. Who is seller? Who is buyer? Who is what? Because the characters will be confusing. It will be, remember, you will be seeing 30 different characters. Who is what only you will forget of. Draw means what, sir? I take pen and take pencil. At least for your understanding, when you're seeing, don't touch question paper. In your answer script, draw. If you don't need it, take it off later. It's okay. But when you're doing it, see it, what is happening. You will get better clarity. Hello? Very important, remember. And whenever there is a direct question, again, you know, I know, we don't know enough points to write for 5 marks. Then how do we do? In your jalebi, add one extra kaju barfi, that is example, relevant. Direct questions, the only way to increase the length, people, is by adding example. Please don't write examples for indirect questions, case-based questions. And next one, people, very, very important point is what? Sir, should we remember case laws? If at all same scenarios come, people, yes, we need to write the case laws. Compared to sections and case laws, forget sections, try to remember case law. That is point 1. Another common question you guys will have, should we explain the case laws? Answer is no, not required. Just write the case law and say, the facts in the question are similar to a decided case law, Balfour versus Balfour. Again, I repeat, the facts in the question are similar to decided case law, Balfour versus Balfour. Is this clear? All of you? Hello? Remember, most important chapters, very, very important. Do not try to skip these topics before the exam. This is Indian Regulatory Framework, followed by LLP, followed by Companies Act, followed by Indian Partnership, Negotiable Instruments, Sale of Goods Act, Indian Contract Act. Day before the exam, you guys will revise in this order. Hello? Remember? Pakka? So remember, these things are very, very important from your exam point of view. Clear? Any doubts? So put this into use and see, I hope it is going to make difference. Especially now, you guys might have another 20 days, 30 days left, whatever it is. This is going to be a game changer for you. Your mind should automatically start thinking from these 3 points. Is heading there in my answer? Is subheading there in my answer? Is keywords are there in my answer? Getting the point? All of you? Yep. Okay. Sure. What is that? Now we have to do this one, no? Okay, taka we'll do up this paper. We'll end up for the day. See, also elaborate the procedure for making a law. So let us continue with people. Okay, let us continue with, what is this? What are we doing there? RTP. RTP 2026. Yes. As I told you, yes, the only amendment for your thing is people. Small company, paid up capital is 10 crore. Turnover is 100 crore. Rest of it is same. People, see, now September 2026 RTP. What do you understand by law? Also elaborate the procedure. Law, as I told you, it's a set of rules and obligations. We can have different types of law, economic, social, and other types of laws as well. Elaborate the procedure for making the law, people. Remember, instead of writing paragraph, write it in points. Committee, bill, Lok Sabha, Rajya Sabha, President of India's approval, and then official gazette notification. Okay, R owns an electronics store. P visited the store to buy a water purifier priced at 54,000 rupees. He specifically requested R for a purifier with a copper filter. As P wanted to buy the purifier on credit with the intention of paying in 9 equal monthly installments, R demands a guarantor for the transaction. S came forward and gave the guarantee for payment of water purifier. R sold P a water purifier of a specific brand. P made a payment for 4 monthly installments and after that became insolvent. Explain with reference to Indian Contract Act the liability of S as a guarantor to pay the balance price of water purifier to R. See question number 1. Again to our list, add, what is that? Please read the complete question. There can be 2 questions in the same question. Question number 2. What will be your answer if R sold the water purifier misrepresenting it as having a copper filter, while it actually has a normal filter? Neither P nor S was aware of this fact, and upon discovering the truth, P refused to pay the price. In response to P's refusal, R filed the suit against S, the guarantor. Explain with reference to the Indian Contract Act 1872 whether S is liable to pay the balance price of water purifier to R. Yes, people, now think of our way of answering the question. Whenever you are answering a question, indirect based question, you need to write again same thing. Provision, facts. There are 2 conclusions here. Correct? So now what am I going to write? My provision. Try to think where does it fit. I need to think of 3 things now. What is the main heading? What is the subheading? What are the key words that I can write? What is the main heading, people? When does the surety when does the guarantee becomes liable? So in the given case, people, whenever on the failure to repayment by the main party, the guarantee will have to be liable. It's a direct provision. So it's nothing but the meaning of guarantee only. So for my first conclusion, they've given me all the details. 54,000 rupees, 9 installments. 54,000 divided by 9. How much will it be? 6,000. So 6,000 per installment. He has paid 4. 4 6 24 he has paid. How much is not yet paid? 30,000 is not yet paid. I will write, yes, guarantor will be liable to pay the balance price. Please don't write balance price. Write it like this. I am liable to pay 6,000 into 5 months. I need to pay 30,000. Now see, you have written it to the point. Everything you have written. Yes, you will get the complete mark. Hello? Next one. Sir, there is a misrepresentation. Now people, will the guarantee be liable? Now try to put our point here. Do we have provision? Yes. When is the guarantee discharged from a liability? So my first point, the guarantee will be discharged. That's my main heading. Subheading. Misrepresentation, concealment of a fact, co-sureties and all will come. My main heading is what here? Misrepresentation of a fact. Hello? Misrepresentation of a fact which cannot be. Which cannot be? They have clearly given, right? Which cannot be discovered. That means what? We have not been negligent or something. Misrepresentation of a fact which cannot be discovered. Sir, in such case, sir, the guarantee will be discharged as the principal itself is discharged. Hello? So in the second case, people, because it is misrepresentation, the contract will become void and the surety will not be held liable. Understood? All of you? And try to use the same words in your conclusion. Is yes liable to pay the balance? Yes. Yes is liable to pay the balance of 30,000. Where is it? Yes is not liable to pay the balance in the case of misrepresentation. That will be going as my conclusion too. Hello? Yes? Okay, next one. Rahul directs Sarthak to sell laptops for him and agrees to give Sarthak 11% commission on the sale price fixed by Rahul for each laptop. As government of India put restriction on import of laptops, Rahul thought that prices of laptops might go up in near future and he revokes Sarthak's authority for any further sale. Sarthak, before receiving the letter at his end, sold 5 laptops at the price fixed by Rahul. Sarthak asked for 11% commission on sale of 5 laptops for 1 lakh each. Explain under the provisions of Indian Contract 1872 whether sale of laptops after revoking Sarthak's authority is binding on Rahul. Question number 1. Whether Sarthak will be able to recover his commission from Rahul. If yes, what will be the amount of such commission? People try to see what is the case. The scenario comes under people revocation of agency. That's my heading. Hello? When will, no, that's my main heading. When will my agency be effective? Now there is no subheading, it is direct. So when will the, agency of, revocation of agency, my main heading, subheading will be people, agency will be effectively revoked when it comes to the knowledge of the agent, when it comes to the knowledge of the third party in the given case. Now are you getting it? Knowledge is my keyword. Revocation is my keyword. Now write conclusion 1. What? Whether the sale of laptops after revoking Sarthak's authority, is it binding? Now I tell you, remember today's date, examiners are trying to help you. Why do they have to use the same words? It's a hint. People I'm asking from revocation of agency topic. Are you getting it? You will see those words if you actually see it. Now what will I say? The revocation of agency, when did it happen? It happened, people, after the sale happened. So remember, agency will not be effective, people, after the revocation of agency is come to the knowledge of the agent and the third party. In the given case, it happened, people, the sale happened before the revocation of agency, and hence, yes, Sarthak will be liable. Sarthak will be eligible for, the commission. Second one, whether Sarthak will be able to recover his commission? Yes, from Rahul, yes. What will be the amount of commission? 1 lakh is the selling price, Something they have given, no? 1 lakh each into 11% into 5. So 11,000 per laptop into 5, 55,000. That is the commission I can recover. You write this much, macha. Macha, you see this time. You guys put this and see how much you guys are getting in law. Yes, sir. Pakka, I'm telling you, you will see difference in your answers. You will see difference in your marks. Yeah. Okay, right. Next one, sir. Preeti, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of MT Laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum by 31st July 2023. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will be able to pay back on her behalf. After 1 year, when Preeti was asked to pay the outstanding amount with interest, she refused to pay on the ground and told the owner that she is a minor and now he can't recover even a single penny from her. She will be a major on 1st Jan 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will be succeeded in the recovering of the authority. By filing a case against Preeti, a minor, by filing a case against father, by filing a case against Preeti minor for recovering. People, I'll again show you they are helping you. Yes, I'll show you why did this word come. Why should they have given it to you? They are helping you. Instead, they could have just asked, no, can Preeti be made liable after she becomes a major? Why did the word ratify come into picture? They will help. I'm telling you, every question will have a help. Yes. Now, one more point. Again, I'll answer very important thing in this particular thing. What is that? How much should we write, sir? Now, this is a minor thing. We got to know heading. Incompetent to contract. Heading. The agreement is void when the parties are incompetent to contract. Heading. Subheading. When the party is a minor, the agreement is void ab initio. Heading is done. Subheading is done. What is that? I've made sure I've written my main 2 marks. Now, how do I get a 3rd mark? What and all I am supposed to write? They have given me 3 main, things in the question. What is that? I have taken it when I am a minor. As a minor, I am liable. My first keyword is a minor can always plead minority and minor cannot be made liable for any agreements. Every agreement with the minor, void ab initio. That's my first keyword. Second keyword, they have given me about the father. Now try to think in all the rules, which rule speaks about the parent? Minor cannot bind the parent or guardian. Underline, done. They have clearly given, can I make her liable after she becomes a major? A minor's agreement is void ab initio. It cannot be ratified even after attaining majority. My provision solidly I have established. Forget facts. Why? When there are more than one question, don't write facts. Don't waste time. Now directly come to conclusion. Conclusion 1. Can minor be liable? Referring to the provisions, it can be clearly stated that the minor agreement is void ab initio. Very, very important. Conclusion should write. Who is it? Preeti, a minor cannot be made liable. Please don't write the answers vaguely. Point 2. Can father be made liable? We saw father, that is parent or guardian, cannot be held liable. Third one, by filing a case against Preeti, a minor, for recovery of outstanding amount after she attains majority, ratification. 5 on 5 you will get. Pakka. Now you guys test yourself. Where you guys writing so much? Knowledge you all had. Application. Now why I am saying that is, you guys can make a lot of difference in the next 3 days because so many tests you will be doing. Put it in the right spirit. Mr. L let out his residential house to Mr. M for 50,000 per month for a period of 1 year. According to the rental agreement, electricity bill will be paid by L. Now you guys only should tell me the 3 things here. You need to tell me heading, Subheading keywords. We'll see. According to the rental agreement, electricity bill will be paid by L, but L could not pay electricity dues up to 5 months due to his financial hardships. The electricity board sent notice of disconnection if it is not paid within a week's time. To avoid all this, Mr. M paid the electricity bill of 50,000 rupees with penalty. Later on, L refused to reimburse the 50,000 and argued that he has paid bill voluntarily because of his own interest. Decide with reference to the provision of Indian Contract Act whether Mr. M is entitled to be reimbursed by Mr. L. People, again I will prove that the examiner is helping you. Payment made by a interested party. Heading, people. What is heading? Subheading is payment made by an interested party. Where did you guys see payment made by an interested party? Quasi contract. That's my heading. Quasi is not there. It is going to create a very big impact. So quasi contract heading. Now think of subheading. There are so many. It will be payment made by a interested person in the property. Yes. Now my heading, subheading established, sir. Now try to write the keywords. What is that? The keywords in this case will remain the same. That is, whenever a party is equally having an interest in the property, will be allowed to make the payment even in the absence of a contract and will be free to recover the money from the person under operation of law. Quasi contract. It's not voluntary. Getting the point? Yes. So can I recover? Yes, I can recover. Next one, people. Mr. A offered to sell 25 chairs to B at 1,500 per chair on 15th Feb 24. A promised B that he would keep the offer open till 15th Feb 24. However, on 13th Feb 2024, he sold those chairs to Mr. C at 1,700 per chair without the knowledge of Mr. B. Mr. B communicated the acceptance of the above offer on 14th Feb 2024. Advise with reference to the provision of Indian Contract Act whether Mr. B can claim damages from Mr. A. Yes, people, what happened in this case? The question is, people, what is my heading? The heading is, people, it's a standing offer. Second thing, people, an offer can be revoked before the acceptance. So in the given case, this is just an offer. An offer can be revoked at any given time by notice. Hello? So can I revoke the offer? Even if I have said I will keep the offer open till 15th, can I sell it to someone on 12th? I am free to do. Why? Remember that Sir William Anson, you would have seen my matchstick gunpowder. Until offer meets acceptance, it is no contract between me and you. I can tell 100 things. Whatever I want, I will tell. Standing offer, my first finger. Second offer, revocation of offer. Possible, valid. Hello? Understanding? Next one. Mr. A was running an orphanage. His friends, Mr. S, a philanthropist, agreed to donate 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now, Mr. S refused to pay. Whether Mr. A can claim 1.5 lakh from Mr. S with reference to the provision of Indian Contract Act. Tell me heading. Heading. Validity of an agreement, nothing but exceptions to quid pro quo. That's my heading. Subheading. Charity. Keywords. Based upon a promise, if a liability has been incurred or undertaken, underline. That's all, you will get the marks. So in the given case, people, it's a charity and the liability has been incurred. I cannot go back. I am liable to pay. 1.5 lakh can be recovered. I hope you are able to understand that. Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26 Feb 2025. The borrower, Mr. Mukesh, asked for a further loan of 1,50,000. Mr. Sohan agreed but provided the loan in parts on different dates. He provided 1 lakh on 28th Feb and remaining 50,000 on 3rd March. On 10th March 2025, Mr. Mukesh, while paying off part rupees 75,000 to Mr. Sohan, insisted that the lender should adjust 50,000 towards the loan taken on 3rd March and balance on 26th Feb 2025. Mr. Sohan objected to his arrangement and asked the borrower to adjust in the order of date of borrowal of funds. Now you decide whether the contention of Mr. Mukesh correct or otherwise as per the provision of Indian Contract Act. What would be the answer in case borrower does not insist on such order of adjustment of repayment? What is this, people? The first one is, what is this? Appropriation of payment. There will be three things. The first one will always be in the order as recommended by the debtor. So in the given case, the contention of Mr. Mukesh is correct. He will be the first person to specify the order. Second one, sir, what if Mr. Mukesh is silent? The next option will be, people, first one will be debtor or circumstance. Second one, people, if debtor and circumstance both are silent, people, it will be creditor's choice. Correct? Appropriation of payment, heading. Keywords, in the order as prescribed by debtor, in the absence of which it will be in the order prescribed by the creditor. Underline, that's all. If people, am I writing full 5, 6 sentences, then if this is there, you will get the mark. What would be the mode of adjustment? If both are silent, people, then order of repayment. In light of provision of Indian Contract Act, answer the following. Mr. S and Mr. R made contract wherein Mr. S agreed to deliver paper cup manufacture machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise at the time of delivery. Tell me, what will you write? What is the heading? What is the heading? Mr. S and Mr. R made contract wherein S agreed to deliver the paper cup to Mr. R and to receive payment on the date of delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether S is bound to fulfill his promise at the time of delivery. What is the heading? Heading. Anyone who wrote reciprocal promises will get it. First heading is reciprocal promises. Now under reciprocal promises, you saw all the rules. In that one rule, now you wrote heading. Subheading is, people, what? Promiser need not perform unless the promisee is willing to perform, ready and willing to perform. These are the keywords. I came on that day. You are not willing to pay me. Why will I deliver the product? Reciprocal promises. Hello. Mr. Y has given loan to Mr. G of 30,000 rupees, 30 lakh. Mr. G defaulted the loan on due date and debt became time barred. After the time barred debt, Mr. G agreed to settle the full amount to Mr. Y. Whether acceptance of time barred debt contract is enforceable as per Indian Contract Act? Heading, exceptions. Subheading, promise to pay the time barred debt. Yes, it is enforceable. Direct, I'm not doing direct. Let us only do the indirect questions. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer. 100 bags of 10 kg each. Okay. On sale or return basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer K. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? What is the main heading? Sale or approval basis. Okay. Under that, people, okay, that's the main heading. There is no subheading here. When does in sale or in sale or approval basis, what is subheading? When is the acceptance complete? When you signify the approval, you do something equivalent to an acceptance, you keep the product beyond the reasonable period. Here I have not given the acceptance, I have not kept the product beyond the reasonable period, but I have taken it from you, I have further sold it. Out of 100 bags, 5 bags I have sold it, 95 bags it is still with me. 5 bags, acceptance is done, you lose the right of sale or return basis. 95 bags still with you, you can enforce the sale or return basis. See, you're able to frame it? Yes? Hello? Ritvik sold 500 bags of wheat to Anuj. Each bag contains 50 kgs of wheat. Ritvik sent 450 bags by road and Anuj himself took remaining 50 bags. Before Anuj receives delivery of 450 bags sent by road transport, he became bankrupt. Ritvik, being still unpaid, stops the bag in transit. The official receiver on Anoj's insolvency claims the bags. Decide the case with reference to the provision of Sale of Goods Act. People. Rata, help is there. Heading, right of stoppage in transit. Subheading, when does the stoppage transit comes to an end? When the goods are delivered to the buyer or an agent or the carrier on behalf of the buyer. In the given case, people, 450 bags are already delivered and hence the transit has come to an end for the 450 bags. Whereas the rest of the 50 bags are still with Anuj and still in the transit, and hence you can exercise the right to stoppage in transit on those 50 bags. See, try to classify clearly. Mr. Mukesh was running a shop selling good quality washing machines. Mr. Vivan came to his shop and asked for washing machine which is suitable for washing woolen clothes. Mr. Mukesh showed him a particular machine which Mr. Vivan liked and paid for it. Later on, when the machine was delivered to Mr. Vivan's house, it was found that it was the wrong machine and also unfit for washing woolen clothes. He immediately informed Mr. Mukesh about the delivery of the wrong machine. Mr. Mukesh refused to exchange the same, saying that the contract was complete after the delivery of the washing machine and payment of price. With reference to the provision of Sale of Goods Act, discussed whether Mukesh is right in refusing to the exchange of the washing machine. People, one thing I have to tell you people, that unfortunately, our institute is complicating this topic called as implied condition and implied warranty. Unfortunately, they are complicating it. Wantedly, they will show it as one thing and the answer will be written in one way. If you ask me personally, though, I am never happy with one topic of questions that is being asked from the exam's point of view. That has always been Sale of Goods Act, implied condition, implied warranty. This stands as one best example. According to me, I'll tell you what is my answer, people. Clearly, Vivan came to his shop and asked for washing machine which is suitable for washing the woolen clothes. According to me, quality or fitness becomes applicable here. Second point, Mr. Mukesh showed him a particular machine which Vivan liked. If I showed you something, that means what? There is a washing machine in display. Then I will consider this as a sample. So both are there. Agreed? But unfortunately, people, the answer that institute says that is right. This is what is that? Implied condition as to sale by sample and description. Yeah, so I don't know how the description comes into picture here, because the woolen clothes, people, the buyer has asked for it. Seller is telling that it's a washing machine. Hello? So according to me, that is what it is. But yes, and they nowhere write quality or fitness. According to me, Not sure if it is right or wrong, but according to me, it is wrong. Quality or fitness should be there. Hello? Then why should we mention this? Correct? That too, the entire condition is clearly revolving around woolen clothes. That is so clearly quality or fitness. Buyer made known the purpose to the seller and relied upon the seller's decision. Yes? But yes, the answer that they have given is people sale by sample and description. According to me is wrong. According to me it should be quality or fitness should be the first priority. Sample to an extent is okay, but description I'm not sure. Yeah? Okay. Neeraj entered into a contract with Rahul to purchase 1000 liters of mustard oil at the price which would be fixed by Akash. Rahul already delivered 600 liters out of 1000 liters to Neeraj, but when the remaining 400 liters was ready to deliver, Akash denied fixing the price of mustard oil. Rahul asked Neeraj to return the oil already delivered and avoid the delivery of 400 liters. Neeraj sued Rahul for non-delivery of remaining 400 liters. What is this, people? Ascertainment of a price. You can fix the, ascertainment of a price. You can fix the price by the third party. If the third party is unable to arrive at the price, then the contract can be avoided. This is my total points. However, if the product is already delivered, then the buyer needs to pay what is reasonable price. Now, in the given case, people, I have delivered 600 liters. I have not yet delivered 400 liters. For 600 people, you need to pay what is reasonable price. For 400, what is not delivered, the contract can be avoided. Hello? I hope you are understanding. Okay. Indian Partnership Director. Ram and Sarthak are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. Ram introduced Gopal to Sundar, a supplier to the firm, as his newly joined partner. Gopal, knowing that he is not a partner, preferred to keep quiet on such an introduction. This information about Gopal being a partner of the firm was shared by Sundar with another businessman, Madhav. Next day, Sundar supplied the raw material on credit and Madhav lent Rs 5 lakh to the firm for a short period on the understanding that Gopal is a partner of the firm. On due dates, the firm failed to discharge its liability towards both. Advise Gopal whether he is liable to Sundar and Madhav for the aforesaid liability of the firm. Main topic, types of partners, partner by holding out or estoppel. Keywords, the partner will be liable to such outsiders with whom there was a direct, he made known or he did not stop that he is not a partner or he is a partner. So with whomsoever we created that impact, only to them I am liable and not to the people whom they communicate to. So in the given case, people, to Sundar I am liable, to Madhav I am not liable. To whomsoever I directly created an apprehension that I am a partner, only to them I am liable. If they go and tell to someone else further, I am not liable for all of that. If I was there, if I did not stop you, only then I am liable. If you tell to another 100 people, I am not liable. Remember that. That's the answer. Mr. Ram, Mr. Rakesh are working as teachers in Ishwar Chand Vidyasagar and they are good friends. They jointly purchased the flat which was given on rent to Mr. John. It was decided between the landlords and tenants that the rent would be 10,000 per month inclusive of electricity bill. It means electricity bill will be paid by the landlords. By mistake did not pay the electricity bill. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 as penalty. Mr. John claimed 3,000 from Mr. Ram, but Mr. Ram replied that he is liable only for 1,500. Mr. John said that Ram and Rakesh are partners, therefore he can claim the full amount from any of the partners. Explain whether under the provision of Indian partnership, Mr. Ram is liable to pay the whole of the amount to John, that is 3,000 rupees. Simple, people, if I am a partner, I was liable to pay the entire 3,000. But this is the case of people, they have used the word landlord. I am people co-owners. In co-owners, I am liable only for my share. So in the given case, I am liable for 1,500 because it's a co-ownership. Mutual agency is not there. And hence people, there is absence of partnership between these two people, Ram and Rakesh. What exists between them is just the contract of co-ownership. And hence, Mr. Ram is right in his opinion. He is liable only for 1,500 and John has to recover the rest of the money from Mr. Rakesh. That's my answer. Hello. A, B and C are partners in unregistered partnership firm named ABC. Is the suit maintainable in the following cases as per the provision of Indian Partnership Act? What is that? A filed a suit against B who had stolen the goods of the firm. It is unregistered partnership firm itself. Can we file a case against the robber? Criminal case, the thefter, you can file. Civil cases, you can't file. Criminal case, you can file. Today only I told you. A filed a suit against measures A, B, C and associates for claiming shares of the assets on its dissolution. Separation, possible people. Correct? Huh? Realization of assets on dissolution. I can file a case. M filed a suit against the firm, measures A, B, C and associates for the recovery of 10,000. M also owed 4,000 to the firm. The firm claimed a set-off of 4,000. Third parties can file a case on the unregistered firm. But an unregistered firm cannot claim a set-off beyond 100 rupees. So you can file, but I cannot claim a set-off more than 100 rupees. Done. Mr. R, a manufacturer of toys, approached MNO Private Limited for supply of raw material worth 1,50,000. Mr. R was offered a credit period of 1 month. Mr. R went to the companies prior to the due and met Mr. C, an employee at the billing counter, who convinced the former that the payment can be made to him as the billing cashier is on leave. R paid the money and was issued a signed and sealed receipt by Mr. C after the lapse of due date. Mr. R received a recovery notice from the company for the payment of 1,50,000. R informed the company that he had already paid the above amount and being an outsider had genuine reasons to trust Mr. C, who claimed to be employee, and issued him a receipt. The company filed a suit against R for non-payment of dues, discussed the fate of the suit and the liability of Mr. R towards company as on the current date in consonance with the provision of Companies Act. Question number 1. Question number 2. Would your answer be different if a receipt under the company seal was not issued by Mr. C after receiving the payment? Heading people, doctrine of indoor management. When the company, the person has issued the seal, people, we will believe that it is a company's authorized document, people. In the given case, company cannot recover the 1,50,000. If seal was also not put, people, in such case, remember, it becomes a case of suspicion of irregularity. Exceptions to doctrine of indoor management. Heading is doctrine of indoor management. Exception to doctrine of indoor management, that is having suspicion of irregularity. You guys need to have little suspicion. Seal is also not given. You don't know who he is. You cannot act. So in the second case, people, if seal is not given, then you will be liable to pay that 1,50,000 again to the company. Company can reject your claim. Hello. Mr. Vijay sold his business of cotton production to a cotton production company, CPL Private Limited, in which he held all the shares except one, which was held by his wife. He is also the creditor in the company for a certain amount. He also got the insurance of the stock of cotton of CPL Private Limited in his own name and not in the name of the company. After 1 month, all the stocks of the cotton of CPL Private Limited were destroyed by fire. Mr. Vijay filed a claim for such loss with the insurance company. State with reasons that whether the insurance company is liable to pay the claim. The case law, people, Makaura versus Northern Assurance Company. Separate legal entity. The insurance contract should always be in the name of the company. You cannot have it in the name of the shareholder. Case law is important. Makaura, Northern Assurance Company. Alpha School is a Section 8 company which started imparting education on 1st 4 2015. the sole objective of providing education to children of weaker society with a nominal fees depending on another opinion. However, on 31st March 2023, it came to the knowledge of the central government that the said school was operating by violating the objects of its object clause, due to which it was granted the Section 8 company. Describe what powers can be exercised by central government. Whenever a Section 8 company does not follow the rules prescribed under the Act, the central government can either wind up the affairs of the company, amalgamate the company with any other company, and they can also convert the status of the company into any other form of business. If the company is winding up people, I can either transfer the assets to any other similar company, or I can transfer the money to insolvency and bankruptcy fund. That will be my provision. Hello. What do you mean by common sale? Okay, direct questions. Last one we will see. Advik purchased a mobile from Bano. He issued a promissory note to Bano, which was payable on demand, but no specific place for payment was mentioned on it. On maturity, Bano did not present the promissory note for payment. As the promissory note was not duly presented for payment, whether Advik would be discharged from liability under the provision of Negotiable Instruments Act 1881. We saw today only people, presentment rules. Whenever there is no specific place mentioned people, the presentment becomes unnecessary. It's okay. You will be still made liable. Shiva gave a gift of 21,000 to his sister through a check issued in her favor on the occasion of Raksha Bandhan. Afterwards, Shiva informed his sister not to present the check for payment and also informed the bank to stop the payment. Examine the provisions of negotiable instrument. Decide whether Shiva's acts constitute an offence under section 138. What if it was not a gift and legally enforceable debt? Yes, because stopping is considered as to be dishonor of a check only. Yes, people, it is not a legally enforceable debt, and hence it is not an offence under Negotiable Instruments Act. That's all, people. That's the number of questions. So that's your RTP September 2026. Yep. So that's it, people. Wish you guys all the best. Let me know if you guys have any doubts. If you guys need even any more, I don't know, topics or anything more in detail, let me know. I'll try to do topics or videos on those particular things, so that let us try to cover it. As I told you, I've already made one video on case law. I think it's around 1.5 hours or something, people. Just search on YouTube, you will get all the cases right from Indian regulatory framework till the negotiable instruments. Everything is covered letter by letter. Please make use of all of that. Sure. So that's it from my end, people. Thank you so much. See you all. Bye-bye.